There have been no proof of any of the allegations. The defendant is basically trying to paint a picture of plaintiff that he is some horrible person in terms of the allegation of waterboarding.
Mr. Todd.
Thank you, Honor. Your Honor, prior to separation, the parties equally participated in child rearing, and that was the status quo. In essence, basically, the parties partook in joint legal and joint physical prior to separation. Since separation, the defendant has been obstinate towards the plaintiff in terms of really any significant parenting time. However, the defendant continues to call every single day to try to remain in a relationship with the child. In terms of the response, there have been no CPS substantiations of any sort. There was an investigation. The defendant called on plaintiff, and that never resulted in anything. The defendant or the plaintiff has no criminal history outside of a speeding ticket. In terms of the housing for the minor child, the plaintiff does live with his mother at his mother's house. However, the child has his own room and has everything in his room ready to go. There was never any domestic violence charge. We would deny any substance abuse issues. Mr. Favorite does not drink. He does smoke marijuana occasionally. However, he is certainly open to any prohibition upon smoking or drinking during parenting time. In terms of the allegations of any guns, to the best of his knowledge, the child has never had any contact with firearms, unloaded or loaded or whatever. In terms of the firearms that are at his mother's house, there are firearms at his mother's house. However, these are in a locked box, which is in a locked room. There have been no proof of any of the allegations. The defendant is basically trying to paint a picture of plaintiff that he is some kind of horrible person who's abusive. That's actually not accurate whatsoever. He is part of a Christian men's fathers group to help him deal with this parenting time issue, help him become a better father, and help him basically cope with not being able to see his child right now. In terms of the allegation of waterboarding, what happened was that the child got some shampoo in his eyes. Nothing more than that. We have no issue at all with a stipulation there would be no corporal punishment for the child of any kind during parenting time. We don't believe that there is any reason for the court to not have joint legal and joint physical custody in this particular matter.
Thank you. Mr. Omloff.
Your Honor, as I noted in our response, the parties separated in May of 2020. And since then, the plaintiff has seen the child only sporadically, approximately 1 or 2 times a month with no overnights. During that time, plaintiff does simply watches his girlfriend interact with the child. He does use marijuana excessively, drives while high, and my client is observed hitting mailboxes. While doing so, he becomes irate when he's asked to stop. He has threatened to kidnap the child in the past. As far as whether or not the child has his own room at the plaintiff's mother's house, that may be, but there are not enough bedrooms for all of the occupants in that house. As far as the allegations of domestic abuse, they're clear. The plaintiff beat my client multiple times per week while they were together. He threatened her with a gun. He threatened to kill her family. In 2019, my client got a PPO against him when he chased her with a knife, pinned her down on a bed, and tried to stab her. And the reason that he became upset with her was she had just found out that he was sleeping with her cousin. That PPO case was in this court, bearing the case number 2019-2541-PP. The plaintiff did not dispute any of the allegations or contest the PPO in any way. The incident that was referred to in plaintiff's initial motion occurred while the plaintiff was in the United States Marine Corps. He committed an act of domestic violence against my client and then subsequently intimidated her into not pursuing charges against him. He says he's not at fault for any of this. He just blacks out when he's angry. To say that because there's been no criminal charges or criminal convictions against the plaintiff is frankly sad, given that victims of domestic abuse often do not report this or call the police out of fear for their safety. And that's what happened in this case. Tegan suffers from hemiplegic migraines, which can cause bad body aches and paralysis. Thankfully, he is on medication, which has, for the most part, prevented any paralysis issues. Tegan also suffers from anxiety and is currently wearing a heart monitor. What cardiologists try to determine if he suffers from a specific heart condition or if his heart just at times beats abnormally fast. Unfortunately, the plaintiff has made no effort to educate himself on how to deal with these issues, and in fact, disputes that they even exist. To clarify or make a correction on what was in my response, the incident that happened when my client observed Tegan playing with a firearm that thankfully was unloaded occurred at Dominic's grandmother's house, that is the plaintiff's grandmother's house. I accidentally misunderstood my client and put that it happened at Dominic's mother's house. Furthermore, plaintiff's mother did admit that she once left a gun in Tegan's toy box while she was drunk. The plaintiff has left his depression and anxiety medications out. Tegan ended up playing with them, but thankfully did not ingest any of them. The plaintiff has hit Tegan so hard he's left welts on the back of his thighs and would also instruct Tegan to hit his mother. I will also note that the issue of child support was not raised in the plaintiff's motion. We request that child support be paid according to the Michigan child support formula. We would ask that my client be awarded sole legal and physical custody, and that the plaintiff have supervised parenting time at Family and Children's Services or a similar entity, rather than by his own family, who frankly function as his enablers. We would further, ask that there be no corporal punishment or use of any substances during parenting time. Thank you.
Okay, thank you. Anything else, Mr. Todd?
Your Honor, again, we have no issue with no corporal punishment during parenting time. We have no issue with no drug or alcohol use during parenting time. It was actually the defendant's request that while the plaintiff was exercising parenting time, his girlfriend come over, and we deny any of those allegations in regards to this alleged domestic violence incident and how that allegedly happened. Again, my client deserves the presumption of innocence. We have no verification outside of allegations of that anything occurred. Additionally, the plaintiff has made an effort and continues to make an effort to see the child, and he's been denied that opportunity. In terms of the child support, he actually called Lansing before calling me to try to set up that child support process moving forward. So we are respectfully requesting the court order joint legal and joint physical custody.
Okay, thank you. Well, in this particular matter, the court does note that, again, the parties have been separated since approximately 2020. It does appear that the child has been in the care of the defendant for this time. So the court is going to, on a temporary basis, grant to the defendant the legal and physical custody. The court will grant to the plaintiff parenting time, standard calendar parenting time, with the midweeks to begin this week on the 8th, on March 8th, and then the alternating weekends to begin on March 17. I will grant to the defendant the spring break of this year, and then we'll talk about the other after this particular point. Court notes that the plaintiff has agreed that he would not drink or consume marijuana during the time he has the child in his care, so the court will order that. The court will also order that there be no corporal punishment, and the court will order that, again, that the plaintiff will be required to provide the child with all the child's medication and any other medical treatment that is the child is going on at this point. If he's got some sort of a apparatus or something of that nature that the child has to wear or monitor or something of that nature, the court will order that. And the court will order that the plaintiff would pay child support consistent with the child support guidelines, and would order that the parties would exchange their income provided to the other attorney within 10 days of today's date. With that, I'll ask Mr. Todd that you would prepare that order and submit it under 7-day notice of entry. That will conclude this matter at 9:45 a.m. You're free to go. Have a good day.
What you just told me, I don't matter. I don't matter. Most
Okay,
judges
Mr.
would have
Butler,
poured you out a
wanna
long
go-
time ago, sir. You ought to be thankful he's trying to be as fair as he is.
We slept together. That's about it. But we
Okay.
never together. We had intimate sessions with each other, but we never lived together.
Her putting her hands on me, her being volatile, I filed charges against her. I don't know why the police ain't pick it up, just like the same reason they ain't pick up stuff that she said I done. Why am I being so restricted?